Guys, in my previous video, I was talking about the total loss of ships as classified and defined by maritime insurance or maritime law. And in that, I talked about the notice of abandonment issued by the ship owners or charterers, whoever own the vessel or insure the vessel, especially in the case of a constructive total loss where the ship has suffered extensive damages and repair to those damages is more costly than the value of the vessel. So here I thought today I will talk a little bit about the notice of abandonment as well as what is the meaning of subrogation. So these are some terms that you should be familiar with as a mariner preparing in the topic of maritime law. So again, I'm no maritime lawyer, but I'm an ex-mariner who wants to give you some material to prepare for your examinations. So I'll start with subrogation, and subrogation means substituting one creditor for another. Here the insurer's right to subrogation depends upon, so when we talk about insurer, it could be the ship owner or the charterer, and their right to subrogation, that is their right to substitute one creditor for another, depends upon if the owner pays for a total loss, then he is entitled to take over whatever remains of the subject matter. So the subject matter here is the ship, the vessel, of course. All right. So if the owner is paying for a total loss, then the owner can take over whatever remains of the subject matter. It could be the owner, or it could also be the hull and hull insurers. Or if the insurers, the hull insurers are paying for a total loss to the owner, then the hull insurers can take over whatever remains of the vessel. Where the insurers are paying for a partial loss. So again, the insurers could be the hull insurers, the hull and machinery insurers, H&M insurers. The insurer is not entitled to what remains of the subject matter, but is subrogated only to the rights and remedies of the assured. So the assured here is the ship owner or the charter, whoever owns the vessel. Alright, the insurer is the hull and machinery insurance. Alright, so if they are only paying for a partial loss, they cannot claim their right over the remaining of the vessel. They only can be they can only claim right up depending on the insurance agreement made between the ship owner or the charter and the hull and machinery insurers. Whenever the assured, that is the ship owner or the charterer, has given notice of claim to the insurer here is the hull and machinery insurers, automatically subrogation will take place. So in this case, responsibility is passed on to insurer, who may take either of the above two actions. So if the owner or the charterer feels that the vessel is either completely lost or partially lost and claims from the hull and machinery insurers for some kind of compensation, which could be the total compensation or partial compensation, then the hull and machinery insurers, depending on the agreement with the ship owners, can take one of the two actions. Either they can pay for the total loss and take over the entire vessel, or they can pay for the partial loss and then claim whatever is remaining, depending on the agreement between the ship owner and the insurers. In comparison, we have the notice of abandonment. Now, like I said before, in case of a constructive total loss, where the cost of repairs to a vessel is more than the value of the vessel itself, the assured, that is the ship owner, may retain the subject matter, that is the vessel, or abandon the vessel completely and claim for total loss by serving a notice of abandonment. Here you must note that the mere silence of the insurer, that is the hull and machinery insurers, after notice is actually not an acceptance of abandonment. Just because you have served them a notice doesn't mean they will accept it. The insurer is entitled to take over all the interests of the assured and whatever remains of the subject matter. So if the insurer is paying for a total loss, they may take over the vessel or whatever is related to the vessel, the equipments and related machinery. In case of certain circumstances, the hull underwriters may admit the loss, pay all claims, but then refuse acceptance of and leave the assured, that is the ship owner, to bear the cost of removing the wrecks. The notice will be served by the owner only when, in his opinion, he cannot retrieve the property. Alright, so again, it's very similar to what we talked about before. So the insurers, that is the hull and machinery insurers, may pay for the total loss or complete or partial loss, and then it is up to them whether they want to claim the whole ship or they do not claim the whole ship and ask the owner to pay for the removal of the wreck that was caused by an accident of the ship. That could be a grounding, that could be a collision, or simply some other reason. Alright, so I hope you guys understand the difference between subrogation and notice of abandonment, and who issues these, and to whom is it issued. And I'll see you soon in my next video, guys. Bye.